Swayam Prabha. Digital India. Educated India.
Welcome to lecture number 17 of the subject Business Law, and today's topic of discussion is Negotiable Instrument Act 1881 Part 2. I am Dr. Rama Vansal, working as Assistant Professor at Arya College, Ludhiana, and this is a DTH Swayam Prabha MHRD New Delhi sponsored project. Today we are going to discuss the topics regarding parties to negotiable instrument, holder of negotiable instruments, holder in due course, capacity of parties to a negotiable instrument, liabilities of parties to a negotiable instrument, presentment of a negotiable instrument, discharge of parties from liabilities, and dishonor of negotiable instruments. Let's start and discuss the topics in the detail. So first of all, I would like to convey that we have read about the meaning of the negotiable instruments in our previous lecture. In that lecture, we have also discussed about the various types of the negotiable instruments, in which normally we count bill of exchange, promissory note, and the check. Now in this, we are going to study what are the various parties involved in these negotiable instruments. So we will start with first negotiable instrument, that is the parties to a bill of exchange. So bill of exchange covers the following parties. The first one is the drawer. As its name indicates, the person who draws a bill of exchange is called the drawer. That means a person who makes the bill, who draws the bill upon another party is known as the drawer. Second one is the drawee. The person on whom such bill of exchange is being drawn, that means who would be directed in future to pay to the drawer of the bill of exchange, that is called as drawee. And next is the acceptor. The person who accepts the bill is known as the acceptor. As we all know that bill of exchange is to be sent for acceptance. So the person who accepts the bill is known as the acceptor. Normally in 99% cases, drawee is the acceptor of the bill of exchange. The fourth party involved in bill of exchange is the payee. The person to whom the amount of bill is payable is called the payee. And the endorser, when the holder transfers or endorses the instrument to any other person, the holder becomes the endorser. Because bill of exchange is a purely negotiable instrument and it can be further endorsed so many times. So when it is being endorsed, it is being transferred to some other party, and the person who would be the holder of the bill of exchange would become the endorser, and the person to whom the bill is being endorsed would be called as endorsee, which is the next party involved in the bill of exchange. The last party in bill of exchange is the holder. The holder is the person who has the bill before the date of maturity for the payment, and the person who holds the bill till maturity of the bill of exchange is known as the holder. So the parties involved here are drawer, drawee, acceptor, the payee, the endorser, the endorsee, and the holder. So these are the parties, maximum parties to be involved in case of bill of exchange. Next, let's discuss about the parties involved in the promissory note. We all know about the promissory note. It is a promise by one person to pay a certain sum of money to the another, or on order, or the bearer. So here are the parties. Four parties are involved in the promissory note. The first one is the maker. As the drawer in case of bill of exchange, the maker is the person who promises to pay the amount stated in the promissory notes. This is the major difference between the bill of exchange and the promissory note. In case of promissory note, one person has to give the promise to pay. So when the word promise is being used in the promissory note, it makes it valid. So the maker is the person who promises to pay the stated amount. Stated is a certain amount like 2000, 4000, or any other stated amount is to be paid by the who is to be promised to be paid by the maker. Next is the payee, the person named in the promissory note to whom the money is payable. So the in promissory note there should be at least two parties, maker and the payee. The both of the parties may not be the same. So the person to whom the payment is to be made, whose name is to be mentioned in the promissory note, is known as the payee. Next one is the holder. The person who holds till the maturity is known as the holder. Next is the endorser. As in the case of bill of exchange, if because the promissory note is a negotiable instrument and can be transferred further, so the person who transfers the promissory note who endorses the promissory note to the next parties is known as the endorser. So these are the four parties: the maker, the payee, the holder, and the endorser who are involved into a promissory note. Next are the parties to a check. No doubt the parties are different, but the meaning of these parties we have already studied in our previous two slides. One is the drawer who draws the check, the drawee on whom the check is being drawn, the payee to whom the payment is to be made, the holder who holds the check, the endorser who endorses or transfers the check, the endorsee to whom the check is being transferred or endorsed. So there are maximum 6 parties which can be involved in case of a check. So by now we have read about the parties involved in negotiable instrument. Next is the holder of negotiable instrument. Section 8 defines, as we have also read the meaning of holder in previous slides, but here there is a detailed discussion on the meaning of the meaning of holder of the negotiable instrument, which is being covered by the section 8 of Negotiable Instrument Act 1881. So this section defines that holder means any person entitled in his own name to the possession or promissory note, bill of exchange or check, and to recover or receive the amount due thereon from the parties thereto. That means any person who holds any negotiable instrument, for example, any kind of promissory note, any kind of bill of exchange, or any kind of check, and who holds at his own name, right? One thing is to hold it at his own name. Second, the purpose is to recover or to receive the amount due from the parties mentioned in it. So that means holder is a person who possesses the negotiable instrument at his own name with the purpose to receive the amount from the parties mentioned therein. So the person is known as the holder. It is the must that holder must have the possession of the instrument and also the right to recover the money in his own name. That means the possession and ownership of the instrument, these are two different things. So the holder must have the ownership along with the possession of the instrument. Only then the holder can recover the money in his own name. And it is sure that no other person than a holder can sue upon a negotiable instrument. That means in case of default, if the other party do not pay, then the holder can sue for the recovery for the to receive the amount mentioned in the negotiable instrument at his own name. And he can give the valid discharge from the liability. Means once the performance is being made, the payment is being made, that means, and in case of promissory note the promise is being fulfilled, the person holder can give a valid discharge from the liability, and he is the chief person to whom all other parties are liable, right? Next term, which is very important in the negotiable instrument, that is the holder in due course. Section 9 of Negotiable Instrument Act explains the holder in due course. The holder in due course have many features similar to the term of the holder. He is the person, holder in due course is a person who has obtained the possession of a negotiable instrument for some consideration in good faith. That means, along with the features of the holder in due course, in extra of that, should get that negotiable instrument for consideration and in good faith. And when the holder in due course receives this negotiable instrument, he should not have any knowledge, any notice of the defect in the title of the person from whom he has taken it. That means, if the holder of the instrument has any kind of defect in the title of the negotiable instrument, that fact should not be known to the holder in due course. So in case of bearer instruments, a person who has acquired the possession for consideration before the amount mentioned in it became payable becomes the holder in due course. The other important thing to be noticed here, that the possession of the instrument should be taken before the maturity date. And in case of order instruments, a person who became the payee or endorsee of this instrument before the amount mentioned in it became payable. That means, in case of bearer who has the possession, in case of order instrument to whom the instrument is being endorsed or is being transferred, becomes the holder in due course according to section 9 of Negotiable Instrument Act. So there are a few essentials of a person claiming to be a holder in due course. That means, if we consider a person as a holder in due course, there are few essential conditions which must be fulfilled before that. One, the person must have acquired the possession of the instrument for valuable consideration. That means, some kind of consideration must have been paid to get that negotiable instrument. And person must have obtained the possession before the amount mentioned therein become payable. As I have already told, that if any instrument is being transferred before the maturity of that negotiable instrument, only then the person who holds it can be known as a holder in due course. Any negotiable transferred after the maturity date would not be a valid transfer. The person has taken the delivery of the instrument in good faith, and he should not have any knowledge about any defect in the title of the person involved. Next is, the instrument should be complete on face of it. That means, all the formalities regarding the negotiable instrument, for example, the name of the drawer, name of the drawee, the date, the stamp, the signs, the certain amount, everything should be mentioned on the face of the negotiable instrument. So, next we are going to discuss the qualification of a holder in due course. First is the he must be a holder. Holder means he should have the possession of the instrument and it should be at his own name. If the possession is there but the ownership is not there, that means the instrument is not at his own name. This is not a valid qualification to become a holder in due course. And he must have got the legal title of that negotiable instrument, means he should be legally owner of that legally owner of the negotiable instrument. And this transfer, this endorsement must be done with the purpose to recover the amount from the parties liable to pay that particular amount mentioned in that negotiable instrument. Next is the he must be a holder for valuable consideration. So the holder in due course must be the holder for valuable consideration. That means consideration need not to be adequate. It is required that consideration must be there, but consideration need not to be adequate. Let's say an example, right? If a car is being car value with value of rupees 1 lakh is being sold for only rupees 10,000. So this would be considered as a valid consideration. No doubt the consideration is not adequate, but the presence of consideration makes it valid. So any instrument acquired by way of gift is not a holder in due course. That means without consideration, a contract, a negotiable instrument cannot be a valid negotiable instrument, or it cannot be held by the holder in due course. And the consideration paid must be the lawful consideration. Let's say an example, suppose the consideration is paid to kill a person. So here the object of the consideration paid is totally unlawful. So this type of consideration paid would not be considered as valid. So that means, in short, we must say that the holder in due course must be holder for valuable consideration for the for anything which is lawful. Next is, he must have become holder of negotiable instrument before its maturity. Once the maturity date has come, when the maturity date has arrived, so no such negotiable instrument can be transferred and and nobody cannot be a holder in due course. But this is possible only with single exception, that is in the case of the accommodation bills. So next is, he must take the negotiable instrument complete and regular on the face of it. So when a negotiable instrument is being transferred or endorsed to the other person, it becomes the duty of the person holder in due course to check that, to examine that, is the form complete, is all the content of the negotiable instruments are thoroughly complete on its face or not, and if any kind of material alteration is there, so is that material alteration being signed by the drawer of the instrument or the maker of the instrument. So if the signatures are not there, any cutting is there, so it cannot be treated as a valid negotiable instrument, and the person holding it cannot be considered to be qualified for holder in due course. Next is, he must have become holder in good faith. When the holder in due course has taken the negotiable instrument, it is normally presumed that he has taken all the necessary precautions in finding the transferor's good title. So if he has used his great care and taken all the precautions, and he don't have any knowledge about the defective title of the transferor, then the person who holds the negotiable instrument, is the holder in due course. Next is, he must take the instrument without any negligence on his part. Means if the person while taking the negotiable instrument has totally ignored the things which are visibly clear, so the person cannot be a true holder in due course. Let's see the example. When any person takes a bill which has been torn and pieces pasted together, so at least if the tear appears to show an intention to cancel it without inquiry, he is not a holder in due course. That means it was very much clear on the face of the bill of exchange that it was intentionally torn into the pieces, then it was pasted. The intention to torn was to cancel the bill of exchange. So that means this type of negligence, if is being done by the holder in due course, so he would not be treated as a holder in due course. So all above are the qualifications for a holder in due course. Next, let's discuss privileges of a holder in due course. That means what kind of benefits, what kind of privileges are being given to holder in due course. One is the presumptions. Presumptions are being discussed under section 118 of Negotiable Instrument Act. So under the presumptions, the first assumption is that every holder is a holder in due course. The person who holds the bill is a holder in due course. The burden of proving his title does not lie on him. That means the person who is a holder in due course need not to prove that he has taken the negotiable instrument in good faith and without having any knowledge about the defective title of the instrument or other things. So the a qualified holder in due course can file a suit in his own name in case the other parties default in paying for the instruments. Next is the inchoate stamped instruments covered under section 20. Inchoate stamped instruments are those instruments which are not yet complete. Some part is being left yet to complete that instrument. So a holder in due course can fill in an inchoate stamped instrument for any amount provided the stamp is sufficient to cover the amount, and the person who has signed and delivered an inchoate instrument cannot plead against the holder in due course that he has made some kind of fraud, he is mistaken or something else, and the instrument must have been completed before it was negotiated to the holder in due course. So all these conditions, all these things can be done in case of inchoate stamped instruments covered under section 20. Next is the liability of prior parties, which is being covered under section 36. So every prior party is liable to holder in due course until the instrument is duly satisfied. It's a very important point to be noticed here that all the parties before the holder in due course which have their respective liabilities regarding the negotiable instrument must fulfill their liabilities until the instrument is duly satisfied. Next is fictitious drawer or pay covered under section 42. The acceptor of a bill of exchange cannot plead against a holder in due course that the bill is drawn in a fictitious name, because the holder in due course holds the good title as good as the title of the holder. So he has taken the instrument in good faith without any knowledge of the defective title of the holder. So he cannot be claimed that holder in due course that the bill is drawn in a fictitious name. No effect of conditional delivery. The other parties to the instrument cannot escape liability on the ground that the delivery of the instrument was conditioned or for a special purpose only, because it is the holder in due course, if he receives the instrument with some conditions, so it loses its features of the negotiability. So the other parties cannot escape from their liabilities that the delivery of instrument was done with some specified conditions or some specified purpose. Next is instrument cured of all defects. According to section 53, a holder in due course serves as a channel to protect all subsequent holders. Anybody who takes a negotiable instrument from a holder in due course can recover the amount from all parties prior to such holder. And the principle lies that an instrument once free from defects is always free. So it is being presumed that if the first holder of the instrument has the good title for that, so the holders after him, means the holder in due course after the holder, would have the good title of the negotiable instrument as was with the holder. Next is instrument obtained by unlawful means covered under section 58. So the person liable on an instrument cannot plead against the holder in due course. That means if any person who has obtained the instrument by unlawful means, the person on this basis cannot plead against the holder in due course on the ground that the instrument was lost or obtained by unlawful means does not make a person discharged from his liability. Next is estoppel against denying original validity of the instrument, section 120. No maker in a suit made by a holder in due course is permitted to deny the validity of the instruments as originally made or drawn, means nothing kind of estoppel can be provided to the holder in due course. Next is estoppel against denying capacity of the payee to endorsee. It is being covered by section 121. So the maker of a negotiable instrument is precluded from denying against a holder in due course the existence of the payee and his capacity to endorse. That means every payee of the negotiable instrument, every maker of the negotiable instrument would always be precluded that from the fact that the existence of the payee and the capacity of his endorsement are the valid one. They have this capacity to endorse it and to pay for it. Next is estoppel against denying capacity of the paying to endorsee. That is covered under section 121. The maker of the negotiable instrument is precluded from denying against a holder in due course the existence of the pay and his capacity to endorse. Any person who has the valid hold of the negotiable instrument has the capacity to endorse it. So it cannot be stopped. Next, estoppel against denying signature or capacity of prior parties, section 122. So an endorser of a bill is stopped from denying against such holder the genuineness and the regularity of the drawer signature. That means the signature, which is a must condition for a valid negotiable instrument, that is the drawer signature, must be checked through its genuineness and its regularity of the capacity of the drawers to make the signatures on any negotiable instrument. Now let's discuss the difference between the holder and holder in due course. We have discussed these two terms by now. So first difference is the difference on the basis of the meaning. Any person entitled in his own name to the possession of the negotiable instrument is known as the holder. And any person who is a holder who takes the instrument in good faith for consideration before its maturity, that person is known as holder in due course. Next point of difference is the consideration. In case of holder, consideration may not pass from a holder of the instrument. But if to become a holder in due course, a person who claims to be a holder in due course must show that he acquired the instrument for some consideration. Consideration is the main important thing to become a holder in due course. Next is regarding the title. The holder does not acquire a better title than that of a person from whom he acquired the instrument, because he has not acquired it is not required that he has to acquire it for some consideration. But in case of holder in due course, the holder in due course always gets a better title, good title than the holder. The reason is that holder in due course don't have any knowledge about the defect in the title of the prior parties of the instruments. So that means the holder in due course holds the instrument in good faith with consideration without the knowledge of any defect in the title. So he is having the better title than the holder himself. Next point of difference is the liability. The holder of the instrument can enforce it against the person who has signed it and also against the transferor from whom he had obtained it. But in case of holder in due course cancel all prior parties to a negotiable instrument until instrument is duly satisfied. Once it is being matured, it is being paid, all the parties are being cancelled into the process. Next point of difference is the maturity. A holder may acquire the instrument even after it has become due for payment. But in case of holder in due course, a person will be a holder in due course only if he acquires the instrument before the amount mentioned in it become payable. That means a person will remain holder in due course until the mentioned amount become payable. So the maturity would, once the maturity is there, the holder in due course would come to an end. So these are the points of difference between a holder and holder in due course. Next, let's discuss about the capacity of the parties to a negotiable instrument. We have learned about the various parties of a negotiable instrument. Now it becomes important to know about that who can be a party to a negotiable instrument. That means who can be the valid party, who has the capacity to become the party of a negotiable instrument. The first one is the minor. The any contract with the minor is always void ab initio. That means a person who is a minor cannot be a party to a contract. That means if the person who is a minor cannot be a party to a contract, so similarly he cannot set up a good title against a holder in due course. So a minor may draw, endorse, deliver and negotiate a promissory note or bill of exchange or check, but he cannot be a holder in due course. He can draw a check provided he has funds with the bank. We said that a minor may draw the check, but this condition is possible only when the minor has sufficient funds in his bank account. And if there is some instrument which is being signed by two persons, one person is major, one person is minor, they have jointly signed it, only the major would be liable for that signatures, not the minor one, as the reason is the contract with minor is void ab initio. No contract can be enforced at the law if it is done with the minor. So in this case, if the instrument is signed by more than one persons, that means from one minor, one major, only the major would be held liable. Second basis of capacity is the insolvency. So the insolvent cannot accept or endorse a bill. The person who is adjudged as insolvent by the court cannot accept any kind of bill or further cannot endorse any kind of bill. And if the insolvent person do this, so the holder in due course can recover from all parties except the insolvent. That means any if it would be the loss of the holder in due course to get a bill from a insolvent person. Third one is the persons of unsound mind. Any kind of bill, any kind of promissory note or notes drawn by the lunatics, persons of unsound mind, are void, as against them the other parties remain liable. That means any kind of person of unsound mind who may be the lunatic or who may be due to some any other reason, the person is not of a sound mind, cannot be a party to a negotiable instrument. Next is the case of partners. Each partner has authority to bind his co-partner by drawing, making, endorsing, accepting, transferring negotiable bills, checks and other negotiable papers in the name and on account of partnership. They can do this. They has this authority. Next, Hindu joint family. If a bill or promissory note is executed by the manager of a Hindu joint family, so or he has borrowed some money for the family purpose, so the same is binding on all the members of the joint family and and it can be enforced against them. Means any act which is being executed by the manager for Hindu joint family is binding upon all the members of Hindu joint family. Last one is the corporation. The power of a corporation to bind itself by bills and checks is derived from its memorandum of association. As we all know, corporation or company is an artificial person. It cannot sign with its own name. It cannot sign. So it works, it operates through its members, and the members has to work according to the memorandum of association. So it is being said the power of the company or corporation to bind itself by any kind of bill of exchange and checks, it is derived from its memorandum of association. Last, agent. An agent may be employed for the purpose of drawing, accepting, or endorsing the negotiable instruments on behalf of his principal. As we know, the principal appoints a person who can appoints a person known as agent, and agent has the capacity to bind the principal with his acts. If the agent is working in his drawn capacity, he can bind the principal. So same here, an agent can draw a bill, accept a bill, or endorse any negotiable instrument on behalf of his principal. So in this case, the principal would remain liable. Here the authority of the agent to draw, accept, or negotiable instrument must be expressly conferred by the principal. That means the act done by the agent must come into the authority of the agent, and that authority should be conferred by the principal for doing that particular act. Next, let's discuss about the liabilities of parties to a negotiable instrument. Firstly, we will discuss the liability of the drawer for the parties to a negotiable instrument. The drawer is a person who draws the bill. So, he is bound in case of dishonor by the drawee or acceptor thereof, and to compensate the holder provided due notice of dishonor has been given. So it is a must condition that drawer must receive the notice of dishonor. If the notice is being not given to the drawer regarding the dishonor of the instrument, the drawer would not remain liable. And the liability of the drawer is conditional, and it arises only and only in case of the dishonor of the instrument. Commission on part of the holder to give the notice of dishonor would discharge the drawer from his liability. That means any kind of omission is being done. If the notice is not being given in case of the dishonor of the instrument, the drawer would not be held responsible. Under Section 138 of Negotiable Instrument Act 1881, the drawer can now be criminally prosecuted. Means in case of default, in case of dishonor, and if the proper notice is being given to the drawer of the instrument, in that case, the drawer can be criminally prosecuted under Section 138 of the Negotiable Instrument Act 1881. Next, the liability of drawee of a check. What is the responsibility of a drawee? The drawee of check is always a banker. It is possible only in case of a check. So if the banker refuses to make any kind of payment without any sufficient cause, if there is a sufficient cause, that means the person don't have the money in their bank account or something else is there, he is being instructed not to pay, then the conditions are different. But if a banker refuses to make payment without any sufficient cause, then in that case banker would be held liable to compensate the drawer for any kind of loss or damage of the goodwill. Third one is liability of maker of note or acceptor of bill. So the maker of promissory note is bound to pay the amount of instrument at the maturity. The maker makes a promise that he would pay for the instrument at some specified date, so he is bound to pay that. As soon as he signs that promissory note and delivers it to the other party, he becomes liable to the payee or to the holder of the negotiable instrument. And the liability of the acceptor is very much similar to that of a maker. And according to Section 32, the acceptor of a bill of exchange is bound to pay the amount to the holder on demand. Promissory note, if it got matured, so it is to be paid on demand. Next is liability of endorser. If a bill gets dishonor, the endorser will compensate the holder or a subsequent endorser. So here the liability of endorser is towards the holder of the negotiable instrument or with the regarding the subsequent endorsers. Every endorser after dishonor is liable as upon an instrument payable on demand. Next is liability of prior parties to holder in due course. Negotiable instrument may pass from several hands, means it can be transferred, it can be endorsed so many times. So it is very important to fix the responsibility of the each signatory of the negotiable instrument. So liability of each signatory to a subsequent holder in due course means to fill is would be there if instrument is till the instrument is duly satisfied. Next topic of discussion is the presentment of a negotiable instrument. Presentment means what? Presentment means placing of a negotiable instrument before a drawee. So, presentment means when one person places the negotiable instrument in front of the other party of the instrument, that is called as presentment. So, presentment may be for any of the three purposes. One is presentment for acceptance, presentment for sight, and last one is presentment for payment. Means any negotiable instrument can be placed before a drawee for three purposes, either for acceptance or for sight or for payment. Let's discuss these three in detail. First one is presentment for acceptance. Only the bill of exchange is presented for acceptance. No promissory note, no check is presented for acceptance. This is possible only in case of bill of exchange. And it is also not necessary to present every bill for acceptance. The bills payable on demand or payable on fixed date need not to be presented. Means the bills on which the fixed date is there or they are payable on demand. So those kinds of bill of exchange are not to be presented for acceptance. And if the bill of exchange is payable after sight, then it is necessary to present the bill to fix the due date of the bill, and it is necessary where there is an express stipulation for presentation. That means if in any case the bill of exchange is to be presented, that means it is expressly stipulated that the bill of exchange must be presented for acceptance, so it would be presented for the same. So when we can say that it is a valid acceptance, first the acceptance must be given in writing. So if it is a verbal acceptance, it cannot be considered as a valid one. It must be signed by the drawee or his authorized agent. Any kind of valid acceptance which is to be given in writing can be given by giving a sign, and that sign must be of the drawee or of his authorized agent, and the signature must appear on the face of the bill of exchange, and it should be presented for acceptance on specified time, and if some specified time is not mentioned, then in absence of that the reasonable time would be counted as the specified time for presentment for acceptance of bill of exchange, and it should be presented for acceptance at a specified place. If the specified place is not mentioned, then the business place, and if the business place is not there, then the residence of the drawee would be the place where the bill of exchange is to be presented for acceptance. Now, how the mode of how the acceptance is being given, what is the modes of acceptance of bill of exchange? The first one is the general or absolute acceptance. That means when the acceptance to bill of exchange is given without any condition or the qualification. No condition is being attached, just the signatures are being put down on the face of the bill. That makes the valid acceptance, and this type of acceptance is known as the general or absolute acceptance. And in case of general or absolute acceptance, there is no need to write the word accepted. Just the signature of the drawee makes it a valid acceptance, and a holder is entitled to unconditional acceptance. Means in case of general or absolute acceptance, no any kind of condition can be attached to the acceptance. Second one is the qualified acceptance or the conditional acceptance. When any kind of condition or qualification is being added while giving the acceptance for bill of exchange, it is called as the qualified acceptance. And in case if the holder don't want to accept that particular condition or don't want to accept that particular qualification attached to the acceptance of the bill of exchange, he may treat the bill as dishonored. And if the holder accepts that condition, then all the parties shall stand discharged. only the person who accepts the condition, who accepts the qualification, would be now liable to pay for it, and if their consent was not taken on the qualified acceptance. Let's see the example. Where a drawee writes any of the following conditions, it is a qualified acceptance: accepted on sale of my house. That means the bill of exchange is accepted here, but the condition attached is on the sale of my house. When the house would be sold, only then the bill would be accepted. Accepted for rupees 1000 only against an amount of rupees 5000 written on the bill. If the bill is for rupees 5000, complete bill is regarding rupees 5000, and it is being accepted for rupees 1000 only, then it is a example of qualified acceptance. Accepted 3 months after date against 2 months written on the bill. That means if it is being mentioned 2 months, the period of payment was 2 months, but it is being accepted as 3 months after date. So this means this is a qualified acceptance. In short, if any condition is being added, whatever is being written on bill of exchange, if anything else is being added on that, this is called as qualified acceptance. Second type of acceptance is presentment for sight, means the bill is being presented for sight. So in case if the bills payable after sight are there, the presentment for acceptance is essential before payment. As we have already read, कि if there is a bills payable after sight, in that case, the first case discussed, presentment for acceptance step is the essential step. So in case of promissory note, no acceptance is required. In case of checks, no acceptance is required. This is only required in case of bill of exchange. Where a promissory note is made without after sight, it is necessary to present it for sight in order to fix the maturity of the instrument. And the expression after sight, what it means? It means that payment is not to be demanded till it has been shown to the maker. At sight means the negotiable instrument must be shown to the maker, and till this is not being shown, the payment cannot be demanded. And presentment should be done within a reasonable time. So for every presentment, that means the reasonable time is considered as a valid condition. Third one is the presentment for payment. If the bill of exchange is being presented for payment, that means the objective of presentment is to give the party concerned an opportunity to pay. That means the party would get discharged after the paying of the payment. This is called as presentment for payment. And valid presentation for payment means presentation on the proper day. That means the day which was fixed for payment, that is that on that day the payment is being made. If any hour is being mentioned, any time is was mentioned on bill of exchange to pay for that, so at the proper hour, and it must be done by the proper person. That means the person who was liable to pay for that, at the proper place. Proper place, like it may be some specified place, or it may be in absence of the specified place, it may be the business place of the party, or it may be some residential place in absence of the business place, to the proper person and in the proper manner. If any condition is being mentioned, or some manner is being given there, that the presentment for payment should be in this condition, so all those must be taken care. And in default of presentment, the all parties are discharged from their liabilities. Next, we will discuss rules regarding presentment for payment. When any negotiable instrument is presented for payment, what are the rules regarding that? Presentment through post office means the presentment for payment can be done through the post office. The negotiable instrument can be posted through that. Hours of presentment, it is usually the business hours. For example, a presentment at 12 o'clock when a person has retired to bed would be unreasonable. That means the bill must be presented when it is usually a business hour, 8 to 8, 9 to 9. Any odd time would not be considered as a hour of presentment for payment. Presentment of instrument payable after date or sight, if it is being presented after the said date, after the said site, after the said time, then it would discharge all the parties from their liability. Payment of promissory note payable by installments. A promissory note payable by installments must be presented for payment on the third day after the date fix, because in this case 3 days of grace is being given. So the third day after the date fix for payment for each installment would be the right time to pay. Next is presentment of checks. A check must be presented to a bank on which it is drawn before the relation between drawer and his banker has been altered. That means we know that the check is being drawn on a banker, and banker is always a drawer. So once it is being endorsed, once it is being transferred to the next party, that means the banker has been altered. So before that the check must be presented before for the payment. Place of presentment: where the bill is made or accepted at a specified place, it must be presented at that place for payment. And if the bill is accepted at two places, it must be presented for payment at either of the place. That means if the person has, if the party of the bill of exchange has the option of two places for the presentment of the bill, so in that case any place out of two can be considered as a valid place for the presentment for acceptance. Next is presentment of instrument payable on demand. If it must be, if the bill of exchange or any negotiable instrument must be presented for payment within a reasonable time. Reasonable time, that means either the mentioned specified time, or the 3 days after the specified time, or any reasonable time which is to be considered as reasonable. Next is presentment to agent or local representatives. That means the presentment for acceptance may be made to the authorized agent of maker or the acceptor. If the maker has appointed some agent to work for him, so the presentment for acceptance of the negotiable instrument can be with that authorized agent of maker, which would make him liable. So next we come to discharge of parties from liabilities. When we say that a party of the negotiable instrument is discharged from the liability, so it has two connotations. One is the discharge of the instrument. Second is the discharge of the parties. So the discharge of the instrument is discharge of one of more parties liable to the instrument. When an instrument is discharged, it ceases to be negotiable. But when the discharge of one or more parties to an instrument does not discharge the instrument, that means if an instrument is being discharged, it is the process is over, it ceases to total negotiability. But when there is a discharge of one or more parties to an instrument, it does not mean that the instrument has been discharged. So let's discuss them one by one. The first one is the discharge of instrument. How the instrument is discharged? One, by payment in due course. It is a very usual mode. Means once the payment is being made, that means the instrument is being discharged, and the payment of amount due on the instrument to the holder would result in discharge of the parties. That means the person who was liable to pay for that instrument, that if once he has made the payment, that means he with the discharge of instrument there is a discharge of parties as well. If the instrument is lost and cannot be produced, the person making the payment is entitled to be indemnified. Means if someone has made the payment on behalf of other, so the person who has made the payment in case of loss of the instrument, so the person who has made the payable must be indemnified for that payment. Next is payment is to be made by the maker or acceptor or the drawer. Next, debtor as holder. If a bill of exchange which has been negotiated is at or after maturity held by the acceptor in his own right, so all rights of action their own are extinguished. Next is by express waiver. when the holder of an instrument expressly announces his rights against all the parties to the instrument is discharged. In other words, we can say when the holder of an instrument at or after the maturity of that negotiable instrument absolutely or unconditionally re-announces his rights, in that case the negotiable instrument is discharged. Next is by cancellation. If any negotiable instrument is cancelled, and this cancellation is to be done by the holder, and the intention to cancel the instrument was to release the party from the liability, so this is being called as the discharge of the instrument. Next, we will discuss about the discharge of a party or the parties. So, first is discharge by cancellation. If the holder of the instrument deliberately cancels the document because only to release the parties from their liability, so in that case, this cancellation would discharge the party or parties of a negotiable instrument. So, here the intention was to discharge him from the liability, and it would be inoperative if done without authority or under a mistake. Means when the intention of the holder was not to release the parties from their liability, discharge the parties from their liability, so it would not lead to discharge of parties from their liability. The intention is the main important point while deciding about the discharge of party or parties from their liability. Next is discharge by release. If the holder releases any party to instrument by any method other than the cancellation, means if the holder willingly discharge any party, willingly accept the cancellation, so this would be covered under this point. But it is important here to note that the release of one of the joint parties will not release all the parties. Means if there are two or more parties into a negotiable instrument, then if the holder of the instrument release the one party out of two, so it doesn't mean that all the parties are being released, only the party to whom this right is being given would be released. Next is discharge by payment. So payment to the person in possession of the instrument discharges the party. It is a very usual way. Once the payment is being made, the party would automatically get discharged. So the payment must be to the holder or his agent, and payment must be of the whole amount. If some part of the amount is being paid or some performance is left, so it is not called as discharge by payment because a few part of the performance is still left. Next is discharge by allowing drawee more than 48 hours. Let's suppose that if holder allows the drawee more than 48 hours exclusive of public holidays to consider, he will accept the bill or he will not accept the bill, and if the 48 hours has gone without any notice of acceptance, so the liability of the other person has got discharged. So all not only the not only the only that party, but all the parties prior to that would be discharged from their liability to the holder. Next, discharge by delay in presentation of the check. If the check is not presented for payment in the reasonable time. Normally, according to present rules, the check is to be presented in the time period of 3 months. So, if the check is not presented in that specified time period, and due to that the drawer suffers actual damage, maybe or in goodwill or maybe financial losses, so in that case he is discharged to extent of such damage. Next is check payable to order. A banker who pays in due course a check drawn upon him is discharged from the liability, and where the drawer issues are the bearer checks, or the dry bank is discharged if he makes the payment to the bearer. Draft drawn by one branch or another. If the demand draft is drawn by one office of the bank upon another office of the same bank for a specified sum of money, the bank is discharged from the liability. Next is discharge by taking qualified acceptance. If the holder of the bill has assented for the qualified acceptance, so there is no condition that he should accept it. But if he do this, so this is being done at his own risk. So this will discharge all the prior parties, all the parties prior to himself from their liability. Next, discharge by operation of law. In case of death, in case of insolvency, or in case of lapse of time, or in case of merger, the parties will get discharged. Discharge by payment of altered instrument. If there is some material alteration which is being done in the negotiable instrument, it would discharge the parties from their performance. But but sometimes it doesn't appear that to have been so altered. Means sometimes it is not being the materially altered. So this case would, this would be a different case. But in case of material alteration, and it would discharge the parties from their liability. So payment on such an instrument discharges the party liable, provided he makes the payment according to the apparent tenor of the instrument. Next is discharge by material alteration, already being discussed. That means if instrument is materially altered without the consent of all the parties get discharged from their liability. To clear this point more, let's take an example. If the instrument was due with rupees 5,000, but one of the party without the consent of all make it rupees 4,000. So this is a material alteration. So this would discharge other parties from their liability. So when we talk about the material alteration, what it means: alteration of date, alteration of name of the parties involved, alteration of time, means when to give it, alteration of place of payment, alteration of amount, alteration of rate of interest mentioned in the instrument, alteration by the addition of new party, some new parties being added without the consent of all, and tearing of an instrument in a material part, means amount part is being left, or some date part is being torn. So that means if the any kind of alteration is being done without the consent of all these things, that means alteration of date, name, time, place, amount, rate of interest, or from tearing of an instrument in a material part, would lead to discharge of the parties from their liability. Next, let's discuss dishonor of negotiable instrument. So what we mean by the dishonor? Dishonor means not honoring one's obligation, not to perform. That means not honoring, not performing one's obligation is known as the dishonor. So on dishonor of instrument, the holder must give a notice of dishonor to all the previous parties that I am not going to perform, that I am not able to perform. So a negotiable instrument can be dishonored either by non-acceptance or by non-payment. These are the only two ways to get a negotiable instrument dishonored. So a check and a promissory note can only be dishonored by non-payment. That means a bill of exchange can dishonored by either of the two ways, means by non-acceptance or by the non-payment. But a check or promissory note can be dishonored only by the non-payment, because in case of check and promissory note, acceptance is not necessary. So let's discuss in detail. First one is dishonor by non-acceptance. Section 91 explains that if the bill of exchange was presented for acceptance and the bill is not accepted within 48 hours, so it would get dishonor. If the drawee is a fictitious person, it would get dishonor. And if the drawee is incompetent to contract, we have already discussed the person who are incompetent to contract are the party of the negotiable instrument, it would get dishonor. And when the bill is accepted with a qualified acceptance, it should be general or absolute acceptance, but if it is a qualified acceptance, even then it would be dishonored. When the drawee has either become insolvent or is dead, or when the presentment for acceptance is excused and bill is not accepted. So in all these cases, the bill is not accepted. This dishonor by non-acceptance is applicable only on bill of exchange, not on a promissory note and on the checks. Second is dishonor by non-payment, covered under section 92 of negotiable instrument Act in 1881. So this is possible in case of bill of exchange, or in case of promissory note, or in case of checks. So if the acceptor fails to make payment when it was due, a due date was there, the party has failed to perform. So this is called as dishonor by non-payment. And in case of promissory note, if the maker fails to make payment on the due date, check is dishonored as soon as the banker refuses to pay. Banker may refuse to pay due to the lack of funds, due to the notice not to pay, or due to some other instructions, or due to their own negligence. So the reason may be any, but any kind of the refusal from the banker side would make a check dishonored. And what would be the effect of dishonor? The other parties there too can be charged with the liability. For example, if the acceptor of a bill dishonors the bill, the holder may bring an action against the drawer and the endorsers. So this is about the dishonor by the non-payment. So in this lecture, we have discussed about the parties to a negotiable instrument. That means the parties involved in case of bill of exchange, in case of promissory notes, and in case of checks. Holder of negotiable instrument and holder in due course. And then we have done the difference between these two terms, that what is the holder and what is holder in due course. Capacity of parties to a negotiable instrument, which can be affected their validity, that is the minor person, unsound mind person, then the insolvents, and the partners, Hindu joint family, etc. Liability of parties to a negotiable instrument. We have discussed the liability of maker, liability of drawer, drawee, and all that. Presentment of a negotiable instrument can be for three purposes: a presentment for acceptance, presentment for sight, and presentment for payment. We discussed it in detail. Discharge of parties from liabilities. That means it may be discharge of instrument or discharge of parties. We have separately studied about it. And at last, we have discussed about the dishonor of negotiable instrument. Dishonor means when the party on the due date fails to perform his liability, fails to perform, that means we'll say that the negotiable instrument is got dishonored. So this is all about this lecture, and this is the end of lecture. Thank you so much.